It's starting now. It should have started. Okay. So welcome back. We are starting the second part after the important executive summary and experience from Sajad. This second part, let me close the transcription, is going to focus on intellectual property rights. Obviously, an introduction to intellectual property rights, as there is a huge amount of material on them, and not all is precisely relevant. So only a short introduction, let's say. So on the current slide, let's move this thing, and let's start the okay. Now you should see the full screen, correct? Lovely. So again, we've gone over the first part. Now we move on to the introduction to intellectual property rights. So before we start with the all three sections, I'm not a teacher here. I am using some primary sources, both from my experience with a startup development project earlier on before Remedy, and several courses and programs such as Work Innovations, Università Bocconi, which is the where I participate the Startup Pre-Acceleration Program, and several impact seminar series from School of Engineering, WNG, which is the Warwick Manufacturing Group, and the Warwick Institute of Engagement. So several mentors, several teachers, all very qualified people. So feel free to ask questions and I can provide the material afterwards. So the first part is the introduction to intellectual property rights. The focus again is for academic, mainly for young academic, but it's applicable also to people outside of academia. First of all, what is impact? Impact, Sajad has already introduced the concept of impact, what it is and where we need it. Impact can be defined as effect, change or benefit of research towards and beyond academia. So it's something that citations by other scientists don't count. It is evidence, demonstrable contribution to society. It is becoming increasingly important. It can consist of patents, so a demonstrable contribution to the world outside of academia, citations by policymakers or by companies in the aim of improving processes, public engagement, outreach activities, or the writing, for example, of policy briefs, which is something that we have seen earlier this year with the GSTC4 course in Milan. So this is what impact is. Impact is relatively difficult to define and quantify. That is because it can be delocalized in time and leading to attribution issues. For example, there are scientific discoveries that lead to a demonstrable contribution to society only decades after the discovery. So maybe you have a publication 10 years ago and the outcomes are 10 years after your publication. Still, focusing on the impact of our research forces us to express and describe our research in different words other than purely scientific, which is an exercise that in itself holds value. Impact is not only important in a vacuum, but it's also increasingly important in funding applications. It's often required nowadays. How can we practically include impact into our funding applications? We can start simple with estimations and projections by asking questions, gathering data, doing some research just a little bit outside the technical aspects. And these estimations and projections can themselves open up new funding opportunities, because we might find that there is an open contract or open opportunities of funding just outside what we were looking into before. And once we started with estimation and projections, we can move on to stakeholder engagement strategies, which mean how we will engage stakeholders, what their role to play will be, such as outreach, funding, and collaborations, and why we are engaging stakeholders, what their role will be. Furthermore, one of the practical strategies we can do that, wait a second, okay, is to engage stakeholders first and then use their pledge, support, and interest as evidence for your impact or for your research. Obviously, the stronger the pledge, so if a stakeholder such as a company or a municipal institution pledges time or money, so funding, it's a much stronger pledge than just considering interest. So the stronger your pledge, the stronger your argument for impact. In practice, there are departments such as universities that can aid us in searching for impact. So just for example, for NEGAR, we can contact the communication engagement department of the academic bodies, such as the Warwick Institute of Engagement, but there are other departments and other institutions that do the same thing, not for Warwick, and gain support in how to establish impact and add impact into our research. If you're really feeling fancy, you can dare and add exit strategies such as intellectual property rights, exit strategies for our research. So what's gonna happen afterwards? So what is IPR, intellectual property rights, the theory, and why they matter for researchers? In short, intellectual property refers to the creation of some of the mind, such as inventions, literary artistic works, design symbols, names, and images used in commerce. This is the definition by the World Intellectual Property Organization. There would be a short video to show, but probably I think we can skip it just to keep it within time. By the way, let me know if there is any change in audio or video. There are many types of intellectual property rights. They serve many different purposes. The most common ones, the ones that we might be most familiar with, are, for example, patents that concern technical innovations, trademarks and know-how, which concern sources of products or services or experience of manufacturing processes, designs and copyright, which is the look of products and creative works, which can include software and code. We'll go deeper into this later. And confidential information, which is just the control of distribution information. Universities are usually holders of a set budget for IP, and this is also true for some companies that do a lot of business into research and innovation. As such, these institutions can support directly inventors, provide budget, and provide consults in the case of wanting to commercialize a product and apply for IPR. What are some different uses of IPR? IPR can serve the purpose of excluding competing projects or technologies, or at least make them more expensive, or preserve or enhance product differentiation. What does this mean? IP is a tool that grants a negative right, meaning it prevents competitors from using the technology without prior agreement. Thus, it can help both in excluding competitors because they cannot pursue the same technology, and preserving product differentiation, because obviously there is a limited potential to replicate the same product if it's protected by a patent. Defensively, to provide insurance or leverage. Patents make you significantly more defensible. Just to give you an example, upon commercialization, one of the questions most often asked by venture capitals and other investors is what's unique about you? So what's there to prevent some outsider with more cash on hand and more resources from copying your product? IP can serve that purpose, can make you more defensive. So the value of a commercially valuable idea increases significantly in the presence of IP. IP can also generate revenue. We'll look into more of this later. They can add value to the company, be an asset, because obviously patents carry a cost in terms of time, expertise, and money. They need to be to obtain them, and to gain prestige and market the product. This is something that could be of great interest to researchers, because having a patent in one's portfolio carries prestige and can lead to funding. Let's just look at a couple of opportunities how IPR can generate revenue directly. One is licensing and the other is spin-outs. Now, as of licensing, we have said before that a patent is a negative right, which means that it excludes others from using your technology for revenue generating activities or whatnot. It is not a positive right. It doesn't automatically grant you the means of production necessary to actually commercialize the invention. This can be a difficult step. Its technology transfer step can be very difficult, particularly in highly capital-intensive industries such as manufacturing or processes. And that's where licensing comes in. Licensing is a license is an agreement between the owner of an IPR, so a licensor, and another party licensee. It grants permission to the licensee to do something that would be an infringement of the negative rights granted by the IPR. So it's a transfer of rights from an owner, the assigner, to an owner, the assignee. It is not as common nowadays, although it used to be very common back in the days. A more common way to pursue commercialization following IPR is spin-outs or spin-off, which are companies that transform technological inventions developed from university that are likely to remain unexploited otherwise. They can take the form of a completely separate entity from the university body, which just provides some consult, or the university body and the department in the university responsible to technology transfer, which is Warwick Innovations in the case of Warwick, or there's a department also for Polyme, I've written it down later, to set up the most appropriate incubation vehicle for the technology, for the service, for the product, which is more common nowadays. The incubation vehicle is just simply whether it's a startup, whether it's whether to pursue IPR, whether to maintain the confidential information. And that's basically, these are the different uses of IPR. Having done an introduction, and this applies to basically all types of IPR, we are working in the field of STEM, so we are particularly interested in patents, which concerns technical innovations, which also includes code. We'll go into this later. And so let's dive a little deeper on patents. But before we do, some terminology. The inventor of a patent is the person who devises the invention. The author of a paper may not always be the inventor, so it's a technical quirk. The author or creator in the case of copyright, and I inserted also copyright because it concerns code or software, which some of us might be interested in as well, is the person who creates the copyright work. The owner of the patent is a completely different issue. It can be, but it's not necessarily the inventor or the author, and depends on the circumstances and on any pre-existing agreements, such as university grants. Focusing on patents, what are the requirements and what not to do before filing for a patent? A patent is used to protect a technical invention, is an IPR, and can relate to a device, so technology, a process, so a series of steps, and some types of software, if an application is already found for the software. We'll clarify this point later. If you're conducting research in the Faculty of Science, Engineering, and Medicine, you're most certainly devising patentable inventions. So we are basically covered. The application of a discovery is usually patentable, whereas software and algorithm are often patentable, although it strongly depends on what it is doing. And what exactly do I mean by that? Is that it depends on whether an application has already been found and what the application actually does, how the software is used. Specific rules for patentability vary by country, but in general, we can define patents with a negative definition, meaning that we can easily define what is not coverable by a patent, and everything else gets included. Things that are usually excluded from patenting are discoveries, scientific theories or mathematical methods, artistic creations, and non-technical schemes and rules. If it's not technical or not yet applicable, it's probably not patentable. Let's go over quickly some of the requirements, and then we'll dive deeper into each of them. So the three main requirements are the invention must be new, the invention must be non-obvious, and the innovation must be plausible. So the application must be plausible. That the invention must be new means that nothing about the invention must be publicly disclosed. So small groups, confidential information, and non-disclosure agreements or NDAs usually work. Let's say that a patent application claims for a smartphone with a touchscreen interface for inputting commands. This would not be patentable because there already exist devices that have these characteristics. The invention must be non-obvious is an artificial concept and is defined as something not obvious is defined as something that colleagues and professionals with access to the same state of the art would consider basically obvious. Let's make an example to make it more clear. Let's say a solar-powered fan attached to a car dashboard. This would probably not be patentable because everybody knows what a solar-powered fan is, and the inventive step of attaching it to a car dashboard is not considered non-obvious enough. This leads us to the, so it's not inventive enough, let's say. The first step is that the innovation must be plausible, and this refers to applications. It's a recently introduced and developing concept which states that the requirement that a patent application must contain sufficient information that it's at least plausible that an application for the patent has been found. This can be particularly relevant for software or code. So if a code is made but an application is not immediately plausible or realistic, then it might not be patentable before an application is actually found. So, having introduced the three concepts, we can look into a more in-depth view into each of them. These are the rules stating the requirements for Europe and the US. As I said, different regions have different patent offices and different requirements for patents, but on average, a new invention is something that does not form part of the state of the art. It's not already available to the public, and this is also repeated in the US form as well. So, say a product has 4 features. There already exists a product with 3 of these 4 features, but the 4th one is new. The product is deemed to be new. But say that a product has 4 features, and the product already exists with these 4 features, and let's say that we add a new feature that doesn't automatically, this is just simply the case, the product is deemed not to be new. More features are required to separate it from the state of the art. This leads to that the narrower the claim, so the more features are in a claim, the more likely that the claim is new. So it can pass this first step. It also needs to pass the next step. So we cannot just add features that don't make any sense, but we'll look into it more. Your own disclosure through online publication of articles counts as public disclosure. So your own work can be cited as private art. So be careful with that before publishing if a patent needs to be filed. This is the rule for the requirement for the non-obvious invention or the need of an inventive step to be real. Again, it needs not to be obvious to a person skilled in the art, to which the same state of the art is available. And let's take the prior example of the product with the 4 features, and let's say that I add a new feature with no clear hint of benefit to the final use, so not really an inventive idea to add onto the existing product, just to separate it from competitors. Then it probably will not constitute as a valid addition to the earlier claim. The last step is the plausibility, and this is an example that was presented in one of the courses. Don't go looking for it because I couldn't find it anymore, but maybe you can find it back. I couldn't find it anymore. But let's take an example of a machine learning algorithm because some of us are interested in this. This is an example of an innovation that was patentable, and it was a machine learning algorithm with a specific purpose implemented in a specific instrument, which was a gas turbine engine part. This is the description that was reported in the patent application. You can look at it relatively quickly, but you will notice that they go into very fine details into what role the machine learning algorithm plays into the device. So it has a very specific function. The application is already found, it's plausible, it's realistic, and this made this machine learning algorithm suitable for patent application. If all of these characteristics were not listed in the patent specification application file, then it may not have been accepted. These are the requirements for patenting. We could go over the patent filing procedure. We won't fully because it's something that's very in-depth and not necessarily super relevant for somebody that is not actively involved into the process, but there is availability of the information if needed. We will look over some of the key data and most interesting data we can find. Let's look at some expectations and timelines. So what would we be looking forward to? The expectation to a patent filing procedure is that the The improvement and the validation process itself that is required during patenting. So the work that, imagine you have a technology that you would like to patent. You go speaking with the relevant department of your university or funding body, and together you work to make the research into a patent filing application. The process and validation and improvements that go into this process will improve the research. So it's not wasted time internally. A patent application process usually takes between 3 and 6 years. It covers the product for up to 20 years from the date of filing. This depends on the type of IPR, and disclosure must not occur before filing. Sometimes it can occur after. A large university like Warwick, just to give you an example, does around 100 invention disclosures per year, which is a preceding step to the patent filing, leading to around 20 patents per year. So it's pretty complicated, time-consuming, and expensive process, as I'm sure you are already aware. Again, before potential filings, do not submit to a journal, as the publication may invalidate the patent application itself, because it counts as prior state of the art. You can usually publicly disclose after the patent filing, but you need to check the journal's policies in case they forbid that. And the last takeaway points could be that patents and IPR are tools which, while valuable in and of themselves, for the reasons that I have explained before, so the prestige, the defensibility, the buying time, the preservation of idea differentiation, they usually lead the way to commercialization. So they're not made just for the sake of it, because there is a lot of resources going to it. Something that you can start to do regardless of whether you want to apply for a patent now or not is to start by, also some of you may become postdoc researchers afterwards, may even lead some of the, in the future may lead your own research groups, is to identify IP-worthy ideas in one's research group. So you can regularly conduct an IP audit when submitting a grant application, when writing a paper, or otherwise sometimes regularly, to keep an eye on what ideas could qualify as an IPR. Identify what is new, what benefits arise, identify who truly contributed to the invention. I'm sure you're already familiar with the concept of authorship and attribution of the work, so the same needs to apply for IPR filing as well. And consider the impact of collaborating with other parties, which could be companies or institutions. The first step that would need to be followed is to discuss with the relevant innovation or patent team. So Warwick Innovation, in this case, is a Warwick, and there's a team in Polyme as well, in the case of Polyme. Or a T2 consultancy. T2 stands for TT, or Technology Transfer, and there are consultancies who specialize in this kind of work. One of them is a source of material for this course itself. It's Venner Shipley. There will be a link at the end of the presentation, and they basically do the job of an innovation department within a university. So they provide consultancy services in the achievement of technology transfer. And some of them have different policies, such as not charging if the patent is not accepted. So there's many differences in that. If valid, if the discussion goes forward and it is identified as an IP valid idea, then you can submit an invention disclosure report, which is separate from the patent filing. And if the invention disclosure report is successful, the 100 that I told you before, then the patent filing may be done. Now, the next slides go very in depth with all of these contents on the procedure. They consider different regions, but let's not go into it now because it's very in depth and may not be relevant right now, and we may forget it before it becomes so. But the take-home messages are that impact offers benefits both you and the university or funding body, whether it's an institution or a company. IPR can be invaluable to gain prestige and to benefit from the value of own research, so through licensing, so generate revenue, and can serve a variety of different purposes as well. Understanding at least the basics of IPR can provide value even without filing a patent. So being aware of what the necessary steps in IPR and what the role the IPR plays is relevant regardless of whether one files a patent or not, such as including exit strategy, stakeholder engagement, and impact into one's funding applications, which may differentiate from others who don't. And knowledge of IPR is valuable both within and outside of academia. Here are some useful links to, as you can see, some websites important for patent applications and patent search. Here are also the technology transfer offices from Warwick, so Warwick Innovation from Polyme, the technology transfer office of Polyme, and Werner Shipley, which is one of those consultancy. Something that you can do as an exercise is to think about your projects, identify innovation from your field or from your work, either from your work yourselves or a colleague or something you've seen recently, and assess patentability. The novelty aspect, the inventive step aspect, so number 2, and the plausibility of application. Lastly, you can consider drafting an IPR exit strategy, which whether it be licensing, spin-out, or copyright. This is different depending on the industry. So if it's a high capital intensive process that you have devised, then you're probably gonna go for licensing. If it's manageable, for spin-out, or if you just don't find really an application yet, you can go for copyright for software, let's say. That is it. I will stop sharing the screen now. We can go to Q&A and the exercise if you wish. And I'll stop sharing the screen.